All right, everyone, we might just get started then. Welcome to today's webinar. Today we're going to be covering workplace investigations, but more specifically, I suppose, the requirements and the obligations on employers to ensure that they're following a fair and legally defensible process. So we're going to go over all the legislation that is applicable to employers and what you need to do to follow that and stay compliant. Some tips and tricks on how to interview your witnesses, how to get that information that you really need, and also just some risk management when we're talking about how to avoid or how to potentially be in a better position to defend claims such as unfair dismissal, general protections, and things of that nature. Just a couple of ground rules before we get stuck into it. I'd say keep your questions till the end. We will have a section at the end where you can ask as many questions as you like, and we can go through and get through all of them. If you do have any of those questions, feel free to put them in the chat at that time. And yeah, guess we'll get started. So firstly, let's talk about why workplace investigations matter. So what we're seeing in the Fair Work Commission specifically is there has been a significant surge in applications, specifically relating to unfair dismissals and general protections. The data is showing, at least for this financial year, that we're actually seeing an even bigger increase than last financial year. So you can see on the PowerPoint there's been a 27% increase that was previous financial year, resulting in a record high of over 40,000 claims, which is extremely significant. There's actually been talk of there being a bit of a backlog in the commission, which means that when these claims are filed, ordinarily there's a process where the employee has to file their claim within 21 days. The employer then gets provided with the claim and they have to provide a response within 7 days, and then we go to a conciliation conference. Now, what we're seeing is that those processes are actually being delayed a bit. Employers are actually getting those applications quite a bit later, but still being held to those very strict timeframes. That's something to keep in mind. There's a lot of claims going back and forth, and conciliation dates seem to be getting set a lot sooner so they can work through the backlog. Now, the data is also showing that given the trend and the increase, we're probably going to be looking at around 55 to 60,000 claims in this financial year, which is, again, a 15 to 20,000 claim increase over the previous financial year. So it's definitely a very prudent and very relevant issue that pretty much all businesses are facing. I know, given the work we do and the clients that we work with, we're seeing ourselves a massive increase in those claims. So we need to know how we can defend ourselves from those claims, particularly when it comes to investigations, and how we can set ourselves up to be in a good spot to say, yes, we followed the process, yes, we've been compliant. Now, there's some legal obligations, obviously, that are incumbent on employers when it comes to the following of a correct process and affording an opportunity to respond in procedural fairness to the employees when conducting an investigation, and we'll get through that here. So specifically with unfair dismissals, we're looking at the criteria of harsh, unjust, and unreasonable, right? So just a quick overview, an employee files a claim. They say, well, I've been unfairly dismissed. I believe that either the process wasn't fair, or there wasn't a valid reason for the dismissal, or I wasn't afforded any procedural fairness, right? Now, they're covered under Section 385 and 387 of the Fair Work Act, which goes through and says that an employer essentially must follow a correct process. The dismissal mustn't be harsh, unjust, or unreasonable. And the thing with employees as well is they only have to get up on one of those criteria, right? So what that means for employers is you could very well have a situation where you have an employee who has done something wrong, they've engaged in serious misconduct, and the conduct is so serious that it warrants immediate dismissal. That doesn't mean, however, that you fire them on the spot, get rid of them, and that you're safe. What it means is that you should likely investigate the conduct, be absolutely sure that the conduct that is alleged has occurred, follow that strict process and go, okay, well, let's have a meeting, let's go through a show cause process, and then have that discussion with the employee, invite them for their opportunity to respond, and then dismiss them. That's a common issue that we see a lot of employers face is, justifiably they've got an employee or someone that they're dealing with who's engaged in serious misconduct, or they've done something so serious that it's harming the business immediately, and they just want to get them out of there as fast as possible. And that's obviously the knee-jerk reaction as well. But really best practice and to put yourself in a situation where you can actually defend against these claims would be to follow those correct processes. So that's just a brief overview of the unfair dismissal claims. Now, the scarier one, and the one that has a bit more risk for employers, is the general protections, right? So general protections claim under section 340 and 341 essentially says that an employee is protected from adverse action from an employer in circumstances where they raise a workplace right. Now, that's relevant for investigations because if we talk about what a workplace right is, it's an employee who raises a complaint or an inquiry in relation to their employment, and they're seeking compliance with the relevant workplace laws. So to give you an example, say you've got an employee who's put in a complaint saying they've been sexually harassed. The complaint is investigated properly, and there's a finding that either the harassment did or didn't occur, and that affects the employee who's made the complaint, either because some of the information got leaked and there's been gossip, or they're forced to work with that individual. They can argue that the employer has actually taken adverse action in either not acting appropriately or in not addressing their complaint in a manner that is compliant with workplace laws. Because what they're essentially asking for when they make a complaint is, I have this issue. This is such a significant issue that it needs to be dealt with immediately and fairly. I expect you to do that. And if you don't do that, obviously they'll say, well, you've taken adverse action against me. The consequences that I either have to work with this person, or maybe they get injured in their role, they have to be redeployed, or there might even be a case where some employers, and certainly we've seen this situation, where the person who's made the complaint actually gets let go when there's been a finding that the complaint was actually based on the evidence bogus or had no standing. And those are all things that give rise to general protections claims. Now, the reason why general protections claims are a lot scarier is because you have to deal with two heads of damage. So firstly, you've got economic loss, which is the time in between when the employee was dismissed until the time of the conference, or if they haven't got a job past the conference and it doesn't settle, then the date of the hearing. And if the commission determines that there's compensation payable, they'll look at that first and they'll say, well, how long have they been out of a job? How have they been injured? And they'll make an assessment based on weeks, essentially. So, they were fired on this date, it's been this many weeks, you're ordered to pay that much compensation. That's the same for unfair dismissals, but where general protections differ is there's that second head of damage, which is general damages. And that's uncapped. So we get into a situation where an employee who has been injured in their role, or they've been terminated or dismissed, they could get medical evidence which demonstrates that they have been psychologically injured, or they've been put in a position where they're struggling to find work. They can then get that evidence and say, look, I've been damaged and I need to be compensated for this. And the court will then determine what a reasonable figure is to be paid out to that individual. So it can be very, very risky. Now, if we move forward, we've got, anti-discrimination laws, workplace health and safety laws, and of course, the Respect at Work reforms. But what we're really talking about with discrimination is, making sure that we're not, in an investigation sense, victimizing individuals because of a protected attribute. So things of that nature would be, because of their race, their sexual orientation, gender identity has been updated to be put in legislation as well, things of that nature. So we have to be mindful of all of these things when we're conducting our investigations. Now, a lot of the common pitfalls that we see when dealing with investigations, especially at the outset, is that allegation letters or letters of, notice of allegations are drafted too vague and they're not documented in writing, right? So what we mean by that is you've got an employee who's essentially, let's give an example, say they've been stealing, right? And the allegation that's put to them is, it is alleged that you have stolen X item on X date. Please provide a response. Now, while in theory, you might go, well, I've put the allegation to them. They're aware of what the conduct is and what I expect from them. What really needs to happen is that you need to detail the allegation very comprehensively. You need to say, we've received a complaint, or it is alleged that you have engaged in this conduct in this specific manner at this date, at this time. We're aware that these were the circumstances around your alleged conduct. And then you provide them the evidence and the documentation which supports the reason for the notice of allegations being put to them. They then have everything they need to go through and say, okay, well, I've got everything the employer has, so I guess I can provide a fully comprehensive response. So that's the first thing. Second thing is the inconsistent treatment between employees or departments. So this is also a common thing that we see in workplaces where, say you've got a high performer or an employee who's, in a law firm sense, I guess, billing to their target or above their target. You've got someone in your organization who's doing really, really well, but then they engage in conduct that is so serious it warrants an investigation. Now, a lot of employers could look at that and go, what is the outcome if we terminate this person? They're an asset to the business, and even though they've engaged in misconduct and they haven't behaved properly, they're still a performer. That's looked at pretty extensively by the Commission, and it's essentially irrespective of their performance or how they are conducting themselves in a performance sense. They are still held to the same standards, the same policies that every other employee is. Everybody has to be treated fairly and equally. It doesn't matter if they're, smashing it at work or they're doing a really good job. If they engage in something like sexual harassment, it needs to be investigated appropriately and needs to be dealt with swiftly. The third one, again, lack of evidence and reliance on hearsay. So hearsay is a big one, obviously. So we have situations where you've got, for example, a sexual harassment claim gets put in, and you've got someone, let's say, that was sitting at a desk or a cubicle, maybe, a couple of meters away, and they think they heard something, or they think they heard a specific thing being said. And then you go through the investigation and you have those discussions and you try and weed out that information. But then you find that no one else can corroborate that story. No one else can confirm whether or not what that certain individual is saying has been said. That kind of information can't really be relied on. If you rely on hearsay evidence, your investigations seem to be deficient and it goes to the Commission will drill you on that point. And they'll say, well, why did you specifically rely on this hearsay evidence and this particular person's testimony over the actual documentation or the actual facts that you have got solidified in stone? We have a case example of that coming up a little bit later, and we'll discuss that in a bit more length. Confidentiality, breaches or gossip spreading, again, another big one. One way to avoid that is when you're drafting your notice of allegations, putting in a section right at the end where you remind the employee of their obligations under their employment contract to maintain confidentiality. You expressly outline that the matter is a very confidential matter and it should not be discussed with any other employee, because in circumstances like that, if they do that, you've issued them a lawful and reasonable direction, and you can say, well, you've gone against the lawful and reasonable direction under Regulation 1.07 of the Fair Work Regulations, that's constituting serious misconduct, and you can terminate them for that reason, right? Again, following a proper process. But it's very important to drill into anyone who's being investigated, just all employees, that matters of this nature are strictly confidential. They are not to be discussed in any manner with any individual in the organization, and to a certain extent outside of the organization, especially if they've got former employees who've been there that are their friends outside of work, and they talk to them about that and the gossip spreads. Then you've got a situation where the complainant is compromised. Their personal information, the details of the alleged event get shared. They might get victimized at work, and then you've got a serious problem. Then the last thing is managers conducting investigations without proper training. So this is also a big one, of course, because investigations are very tricky. They're a bit of an art, because you've got circumstances that apply to every single investigation that you undertake. Circumstances differ between each case. You have to take it on a case-by-case basis. But what we mean by conducting investigations without proper training, what we really mean is managers not being aware of what their obligations are and how to conduct an investigation properly. So we're talking about how to interview witnesses, how to go through relevant information, and how to actually present that notice of allegations to the employee and have that discussion and go through that process. So if we look at what the cost of getting it wrong is, it's quite substantial. And again, there's a case study coming up that we'll talk about, which goes through what some of those consequences are. Firstly, as we discussed, we've got the unfair dismissal claims. The main remedy for an unfair dismissal claim is reinstatement. It's very rarely awarded because if you just take it as a matter of practicality, if an employee's been dismissed, you've pretty much strained that relationship. They most likely wouldn't want to return, and you probably wouldn't want to have them back, right? So where reinstatement's not awarded, in about 95% of cases, maybe more, compensation is awarded. And again, that's on the basis of economic loss, specifically for unfair dismissal claims. And that's capped at 26 weeks. So regardless of circumstances, the most an employee can ever get out of an unfair dismissal claim is 26 weeks. Again, it's not awarded very often. It's a very rare case that an employee is entitled to 26 weeks pay. And again, if we talk about the economic loss, they'd have to be out of work for 26 weeks. Workers' compensation claims, massive one, definitely recently as well. A lot of employees are becoming aware of their right to make a workers' compensation claim, and that can cause, significant strain on your organization and obviously affect your premiums with work cover and things of that nature. Those are very, very powerful claims when put against you, because you've essentially got an employee who's saying, I've been injured either physically or psychologically because of the way that you've mishandled this process or because you haven't addressed my concerns. And it's likely they'll get accepted if they get a medical certificate from their GP or from any treating general practitioner who says, they've been injured because of how you've conducted this process, this investigation. So we need to make sure that we're communicating with the employee in a manner that addresses their concerns, but also that we're doing things in a timely manner. So that's a huge one, workers' compensation claims. Discrimination or harassment complaints, again, for example, if you take an individual who's of a different ethnicity, and they try and argue that the reason you haven't addressed their complaints or their concerns is because of that reason, they can take you through, in Queensland, the Queensland Human Rights Commission, in Victoria, it's VROC. Across all states, there's opportunities and there's avenues for them to bring claims against you. So you have to be very mindful of that. And then, of course, the obvious one, reputational damage. And if we're talking about employees who are filing claims, we see a very consistent trend of one employee files a claim, they might get an outcome, they might get a payout. Another employee catches wind of that, and then all of a sudden you've got 3 or 4 claims, whether it be for workers' compensation or discrimination or unfair dismissal or anything like that, and they just come flying through the door. So it's very important to manage that process, and that's where confidentiality comes in. But we'll talk about that in a little bit. So this is the case study that I was referring to earlier. So in this case, the applicant, Mr. Crook, had alleged that he was unfairly dismissed. The reason for this was because he had allegedly, had an explicit conversation with a female colleague. He allegedly exposed her to illicit images on his phone, and then he was staring at her lewdly and making remarks about her to other employees that were of a sexual nature. The employer had that complaint put to them by the female colleague, and they immediately acted on it, which was a step in the right direction. But they handed him a notice of allegations immediately, asked for his response, didn't afford him proper time to do so, and then followed the investigation with another 2 meetings, and then they terminated him post the investigation. Now, the commission found that it was deeply flawed and deficient, and it lacked rigor. And one of the main reasons in this case was because when the investigation was conducted, none of the witnesses that Mr. Crook had put forward to be interviewed had been interviewed. The female colleague's version of events were entirely favoured over Mr. Crook's. They didn't review the documentation correctly that Mr. Crooks had put forward. They didn't accurately or appropriately consider his response, because if we look at the timeline, they fired him extremely quickly after the complaint was made. That's another key thing to be aware of, is you can conduct an investigation, but if you move too fast, it's going to be very hard to argue that you allowed sufficient time to consider their response and that you actually went through things in an appropriate manner, and that you went through everything with a fine tooth and comb, which is what the commission requires, and that's the standard. The other things that were happening in this case were, there was a swipe card issue where there was an issue of time, and they were arguing over, when the date of the event was and how things were conducted. And Mr. Crooks raised that he had a conflicting statement around when his swipe card was swiped in, around the time that the alleged comments were made, and they just disregarded that completely, and they just didn't review that data. The commission then found that, again, he was unfairly dismissed, and the order was that he had to be reinstated with continuity of service and restoration of lost pay, right? So that, because this went to a hearing, we're talking about, a fairly long process, 6 to 8 months, restoration of lost pay for that period, plus reinstatement, plus continuity of service. And then, of course, no deed of settlement release there because it went to a formal hearing. So if the employee decides again that, he's unfairly dismissed at a further stage, he can make another claim. So it's a fairly strict process, and we need to make sure that we're doing the right thing in terms of going through all the documentation and everything that we're doing there. Now, if we look at the 3 pillars of legally sound investigations, firstly, again, procedural fairness, then we've got impartiality and objectivity, and then evidence-based decision-making. So we'll go through that in more detail in a little bit. But what we're really saying there is, 1, procedural fairness, just make sure you're presenting all the documentation to them and you're giving them a reasonable opportunity to respond and not an unreasonable time frame to respond in. Impartiality and objectivity, making sure the person who's conducting the investigation isn't clouded by their own personal bias. They've got a relationship with the person who the complaint has been made against, managing that conflict, making sure that, if there is a bias there, not allowing them to do this investigation, maybe engaging an external investigator. And then again, evidence-based decision-making, relying on the documents, the facts, not the hearsay, not the opinions, just the facts, just the documents, and how things have unfolded based on the material that you have before you. Now, if we look at the Fair Work Act, procedural fairness is defined as natural justice. So again, informing them of the allegations in clear, specific terms, giving them a genuine opportunity to respond in a reasonable time frame to present evidence, ensuring the investigator is impartial and no personal involvement or bias, and again, based decisions solely on evidence and not on assumptions. Now, the question I always get asked is, what is a reasonable time frame to respond? And that depends. If you've got an allegations letter that's 20 pages long, it's probably not reasonable to get them to respond the next day or even the next 2 days, right? Rule of thumb that I tend to follow is, for each allegation, you should afford at least a day. So if you're looking at 10 allegations, I'd give them probably about 10 days to respond. You can give them a week, but realistically, if there's a lot of material there and there's a lot of issues, you should afford them enough time to be able to go and get their own information together, and they'd only and allow them to collate their response and give a detailed response. So it's very important that we give them enough time, because in a lot of cases we see the process is followed correctly, but then right when we get to the hurdle where we say we need your response, we say you have to respond tomorrow, and that puts pressure on them as well. This is how we get work cover claims, because an employee will say, yes, I understand that these allegations have been put to me and I understand the allegations, but because they only gave me a day to respond, I had an anxiety attack, I got panicked, I was injured psychologically. They go to their doctor, they get a medical certificate, put in a work cover claim. Work cover then determines that unreasonable management action taken in an unreasonable way, and the claim's accepted and your premiums go up. So something to definitely keep in mind there. Now, very quickly, anti-discrimination obligations. Again, making sure that you're treating all the parties equally, regardless of their gender, race, age, disability, beliefs, anything like that. Everybody is equal in the workplace, so we need to make sure that we're treating all complaints with obviously the degree of seriousness that we need to, but we need to be objective and impartial, and we need to be fair and equal to everybody. So even the complainant, we don't just automatically assume the individual's guilty. We go through the process and we afford them that opportunity, and we have that discussion with them and we see what their view is. We don't just make a determination at the first hurdle. Maintaining confidentiality, information only being shared when necessary. So again, making sure that information doesn't leak out to other employees or get given to individuals outside of the organization. You need to keep it pretty airtight, because again, information leaks out, gossip spreads. You've then got a situation where the complainant likely gets victimized, or they get, scolded or, left out by their peers because they've made a complaint and they feel as though they're not trustworthy, which we see fairly often as well. Again, avoid prejudgment, making any predetermined decisions before you've actually done the investigation, and avoid leading questions when you're interviewing your witnesses. It's very important that you don't lead them down a path where you say, for example, you did this on this day, didn't you? It's more so, we've got this material. Can you have a look at that and tell me what your view is of that? And how do you interpret this? And how do you see this? We want to get their perspective, and we want to know what's going on in their head, rather than accusing them from the outset and having them try and fight a battle to try and prove their innocence. And again, the last point, protect participants from victimization or retaliation. That just ties into confidentiality. If you keep it airtight, no one knows about it, and only the individuals who are involved in it know, you're doing pretty well. Now, if we move forward to the next slide, again, yeah, workplace health and safety obligations. Just needing to make sure that we're addressing complaints as soon as they come up. We don't want to waste time and delay investigations or delay responses because, again, if the conduct is so serious and you fire the person saying that it was so serious we had to fire them, if you've delayed the investigation or you've taken too long, it's going to be very difficult to argue that it was so serious you had to fire them as soon as you had the outcome. So being very mindful of your obligations in terms of, psychosocial hazards in the workplace, addressing those complaints in a timely manner, making sure that individuals aren't being victimized, that sort of stuff. Now, if we move forward to when an actual formal investigation is required, usually, in many cases, it's serious misconduct or there's been a significant breach of your policies, right? So we're talking about theft, fraud, violence, bullying, sexual harassment, repeated breaches of company policy, that sort of thing, right? If there's a psychosocial or workplace health and safety risk, someone's acting in a manner that's affecting the mental health of your other employees, or, they position themselves to be in a place of power when they're not, we need to conduct an investigation to see if that conduct actually occurred. And then again, another one that's a bit more, some would say minor, I would say it's not minor, it's actually fairly severe, is ongoing or systemic cultural issues. Because if you look at your team and you look at your employees, workplace culture is very important. And if you've got a culture where, it's toxic or it's been tainted and individuals are feeling as though they're being put down or they're being forced to work in a place where issues aren't addressed, you end up with people resigning, again, people making claims, and you've got a really high turnover rate. And it's just not good for your business generally. Now, when we want to determine the appropriate response, we don't always have to investigate. We can go for the informal resolution route. So if we're looking at minor or isolated incidents, such as, if we look at an example, say, for instance, someone's taken someone else's food in the lunchroom or they've mistakenly eaten someone else's lunch. We don't need to formally investigate a matter like that. We can go for more of a mediation or an informal discussion where we can go, look, what's the issue here? If you're very aggrieved, let's see if we can work this out rather than needing to go through a full investigation process. Again, can be quicker, be less disruptive, and it preserves those relationships because you make it on an informal basis, but you also keep it confidential. You tell them, even though this is a minor issue, we're discussing it between us. You've come to HR. What you share with us is not going to be shared with anybody else. Tell us your view. How would you like to resolve this? But if we go for formal investigations, though, they're absolutely necessary for those serious allegations and those serious breaches. In order to do that, we need to obviously provide structured evidence and interview witnesses, document findings, and present those findings to the employee who is alleged to have engaged in the conduct that has been put to them. Now, we want to assess the nature and the severity of the allegations. So obviously there's a bit of a scale. It goes from, maybe a little bit of workplace banter that could be engaged in by everybody to full-blown sexual harassment or even in some cases sexual assault. Definitely consider the frequency of that conduct and the severity of the conduct and determine whether or not that conduct is so serious that it needs to be investigated. And in most cases, it does, right? If you're unsure, obviously definitely get that advice. You definitely want to get some legal advice when it comes to those more serious issues, because again, if you don't follow the process down to a T, you could have done everything right, but fallen over at the last hurdle. And then, the commission looks at you and goes, well, you were doing well, but you fell over at the last hurdle and therefore we have to award costs to, the applicant in this circumstance and you're at risk. Now, documenting the rationale for your chosen approach. Just as a rule of thumb, just record everything. Not physically in terms of, recording it on your phone, unless you have consent, obviously, but you want to document everything in writing. Any complaints you've received, any witnesses that you've interviewed, any steps that you've taken to try and, minimize risks in the workplace, absolutely everything. Document it, keep a clear record of it, because when you're put before the commission and you're, essentially tasked with explaining yourself as to how you've followed the process and how you've done the right thing, you have all that documentation to support your argument. And you can say, well, these are the steps we took. It also supports the timeline because you can say, no, we did consider the response. Here's all our documents saying that on this date, we considered the response. On this date, we commenced drafting our final termination letter, and then we issued it to the employee. Where all that information is missing, you've essentially got to argue up a hill. And you've got to say, well, at the time we were thinking this, and we just thought that it was so serious we had to fire them immediately. And the commission just doesn't accept arguments like that. They want the documentation, they want the facts, and they want the evidence. Now, if we look at what the role of HR is in investigations, it's ensuring that there is integrity and compliance in terms of your own workplace policies, but also that the integrity of the investigation and how it's conducted is not compromised. So again, confidentiality and making sure that the complaints are addressed properly. Now, the big one is conflict. There's obviously a lot of workplaces where there may be some HR managers that are fairly close with staff, not unreasonably or not unnecessarily, but, say there's a situation where you've got one employee who's quite close with the HR manager and they make a complaint. The HR manager might assess and address that complaint and investigate it differently compared to an employee that they aren't too fond of, right? In circumstances like that, to avoid the conflict, just engage an external investigator. Or if you have another individual that's in the HR department that can go into those complaints and can investigate it and are competent in doing so, consider that as well. Bias is probably one of the biggest things that affects investigations internally, because employees can very strongly argue, well, this HR manager had a relationship with this individual, so clearly the finding has been positive for them because they like the employee or things of that nature. And it happens very, very often. Now, again, seek legal guidance where necessary. Where you look to seek legal guidance from a lawyer, it's actually very beneficial for you for investigations specifically, because you are covered by legal professional privilege. And when you come to a lawyer and you outline the allegations and you talk about everything that's happened, you can actually request, when the commission requests information to be provided, you can detail which documents you want to provide and which documents you don't want to provide, because the documents that you've engaged the lawyer to prepare, such as advice or certain strategies or approaches, they're all covered by privilege, which means that you can get that advice, you can get the way forward for the most compliant way to get through your issues, and then you can have that covered by privilege, and you can be far more protected than if you're required to relinquish every single document requested in circumstances where there's disclosure, or where the other side decides that they think you're hiding something and they want you to provide every little detail and every little document that you have. Legal professional privilege does cover you quite well in those circumstances. That's where we get into this next slide, of course. It's not a full defense, obviously, because you still have to provide your investigation report. You still have to provide, your witness statements and all that sort of stuff. But what it does allow you to do is to get that advice, and get that advice in a privileged way, where you can get a recommendation, from a solicitor, where they go, well, this is what I've seen looking at the evidence. We've investigated it and we find that this is the outcome and this is the recommended approach that we recommend you take. You can have that all available to you before you make that decision, rather than just going at it yourself. So highly, highly recommended. Now, when we talk about engaging an external investigator, it's not appropriate in all circumstances. Again, because there's, the costs associated with it, and then there might be expanded timeframes, because you've got a now third party, you've added another element in the mix, and you've got someone who has to trawl through all the documents. They're not in the workplace, so they might not be as accustomed to what's happening on the ground. But it is appropriate in circumstances where you've got senior staff, including executives or managers, especially those individuals who in essence sit above the HR managers and have a degree of power, where if things don't go their way, they might decide, well, you've brought this investigation to me, I might just terminate your employment, things like that. Definitely engage an external investigator. Situations with high legal risks, such as sexual harassment, discrimination, or potential unfair dismissal, definitely get advice on that before you proceed. And again, as I said before, when you're talking about perceived or actual bias, where you've got that HR manager or that individual who might favor one employee's version of events over another purely because they have their own bias. Now, the perks is that it ensures objectivity, independence, and credibility of the investigation. And you've got someone who's looking at it from an outside perspective, where they can purely just look at those facts, and they can look at the documents and say, well, based on what you've given me, without any bias, without any clouded judgment, this is what we recommend the outcome should be for this investigation. Now, if you look at the selection criteria, they have to be an independent, no prior relationship with any parties that are involved, considerably experienced, definitely, making sure that they've done workplace investigations before, they're aware of what the requirements are under the law and the procedural fairness requirements, and that they're capable of producing well-documented findings that align with the facts and the documents you provided them. Again, we spoke about legal professional privilege, so I won't parrot on about that too much, but just, I guess, take home that that's a big point. And if you do engage a lawyer, you are more protected because of that privilege. And then, again, that last point, scope in terms of reference, you get a purpose and objective of the investigation rather than just jumping in blind and going, well, what's the finding? Each allegation gets investigated thoroughly because obviously if you're engaging a third party, that's all they're doing. And then expected deliverables. So you can set those timeframes, you can have those discussions about when you're expecting to see that outcome, that report, and then you can give that back to the employee and say, well, we've been advised this is when we're going to get a response. So the onus isn't necessarily on you and you're not necessarily the decision maker, but it's rather the third-party investigator who's making the findings. Now, if we talk about the first hurdle, which is planning the investigation, we want to be extremely comprehensive in defining what the allegations are to the employee. So I touched on this a little bit earlier. We want specific dates, times, locations, and all the involved parties. And we want to make sure that we give them all the documentation that they reasonably need to be able to respond to those allegations. We want to identify the witnesses and the evidence sources. We don't just want to say a complaint has been made and now we're going to take action against you and there's an investigation. Obviously, if the complainant has said they'd rather remain anonymous, you can say, you know, for the purposes of confidentiality and for the purposes of this investigation, an individual in the organization has made a complaint against you. This is the evidence and this is the documentation we've been provided. We require that you provide a response. And if the employee demands that the information on who that individual is provided, you can reasonably say, well, no, you know, we've got to protect the employee's confidentiality as well. But in most cases where, you know, the employee hasn't requested to remain confidential or anything like that, you really should provide them with who the complainant is. Again, setting clear timeframes. One of the big things is the conduct happens, say, a month before the investigation even starts, but you're only made aware of it at that time. So it happened a month ago, but someone's only felt comfortable making a complaint a month later. You then investigate it and the employee goes, well, this happened a month ago or 2 months ago or however long ago. How is it only being brought to my attention now? This is where you need to set those clear timelines and go, the alleged conduct was on this date. The complaint was made to us on this date. We have commenced the investigation on this date, and now we're bringing it to you for your response. So it's very important to let the employee know that you're not just bringing this out of the blue, or that, you know, they've maybe engaged in some sort of conduct in the workplace recently that isn't part of the investigation that might have prompted it, because then again, you've got a general protections claim waiting to happen. You want to put yourself in a situation where you can go, here's the timeline, the chronology, essentially. This is how everything came to fruition, and this is why we're in the position we're in now. And then finally, notify all the parties formally. So make sure that you're getting all that information out to those who are affected, letting them know what the timeframes are and letting them know what is actually happening in the investigation. Now, gathering evidence. So we're talking about emails, letters, reports, HR records, policy documents, digital evidence, physical evidence, everything, right? When we conduct an investigation, we need to make sure that we're getting every single bit of information that we possibly can relating to those allegations, whether it be, again, text messages, emails, letters, reports, all that sort of thing. Now, the big one there's the policy documents, right? Because if you've got an employee who has engaged in conduct that doesn't align with, say, your code of conduct or your, disciplinary processes, you can then put that to them and say, well, here's letter of allegations and here's our policy that you would be aware of because you've signed it at the time of commencing your employment. We want you to reread that policy and then come to us with your response to the allegations as to why it hasn't breached that policy. So that they've got everything available to them. They're not just sort of responding to 2 lines of an allegation where they're unsure of what's happening. Again, it ensures reliability and corroboration. So you need to verify that evidence is authentic and accurate. This is again where we talk about hearsay. For the example I mentioned earlier, you've got someone who's sitting there who says, oh, I think I heard this person say this. I can't confirm, and they're the only person that says that. It could just be a matter of opinion. And if you're relying on that as a main point in reaching your determination, that gets attacked by the commission or it goes further, you're probably going to fall over on that point. So again, rely on the facts, the witness statements, the records, digital logs, all that sort of stuff. Make sure you've got that all down pat. And then maintaining a chain of custody. So who's collected each document? Who's taken the notes? Who's done the investigation? How have they done it? What's the time that it was done? All that sort of stuff. You want to keep everything airtight. You want to make sure you can say, well, we conducted interviews on this date. We then met with the complainant on this date. We met with the accused on this date, and then we reached a determination here. Because then again, you can show the whole process and the whole timeline to the commission, and you can say, no, we didn't rush the process. We actually did things very methodically, and these are the dates, and this is how it was conducted, and this is who conducted it. Now, when we're talking about actually interviewing your witnesses and interviewing, the accused and the complainant, we want to be very, very, very careful in how we communicate with them, right? We want to remain calm. It needs to be in a private setting, right? So in a meeting room where there's no one else around, no one can hear what you're saying, it's just you and that person. You want to be very upfront in explaining what the purpose of the meeting is and what the rules are for confidentiality, and just really reinforcing that with the employee. Before the meeting, obviously, when you send them the invite and you give them the notice to attend, you want to offer them the ability to bring a support person if they need to. Take accurate notes or record, again, with consent. But yeah, making sure that you're detailing not just what is said, but how it's said, because we're talking about body language as well and tone. So if you've got an individual who is saying, oh, that wasn't said, but they're sort of rolling their eyes and they've got their, arms tucked in and they seem very defensive, that's a point that you can sort of dip a little bit further into, and you can say, oh, well, you seem a little bit uncomfortable. Can you go into that a bit further? Why is that the case? Again, remaining impartial is extremely important, and avoiding accusatory statements. Just present the facts and the evidence. You don't want a situation where a complaint's been made where someone said, oh, so-and-so, touched me inappropriately in the workplace. And then as soon as you sit down with the accused, you say, right, so we've been told that you touched this person inappropriately. How did you do it? You want to do it in the sense of, this allegation's been brought to us. This is the record of events that we understand. Can you have a look at that and just explain to us what your recollection of the events is? And then when they put their answers forward and they say, oh, well, on this date this happened, you can go, can you give me some more detail? And what do you mean by that? And how was it said? How were you acting? What was your demeanor? That sort of stuff. We don't want to just accuse them outright. And again, if we tie that back into tone, it's very important that we don't just come out aggressively and we just say, you've done this. Now, technical investigation skills. Again, very simply, gather admissible evidence, plan and conduct the interviews, prepare a clear factual report, and then assess and corroborate the information. That's sort of your checklist to make sure that you have to go through. Maintaining confidentiality, we've already touched on. So, share the information on a need-to-know basis. Store your evidence and report securely. That's very, very important, especially with senior employees. You've got access to, parts in the computer or parts in your OneDrive where they could see those documents that are pre-prepared. That could become a massive issue for you. Refrain from discussing the case informally. Just don't have that discussion with anybody who's not outside or who is outside the investigation process. Just keep it airtight and remind them constantly of their confidentiality obligations. Again, as I said earlier, putting it in the letter and saying, we remind you that you must keep this information confidential and you are not to share it. Because again, that becomes a lawful and reasonable direction. If they don't follow that, then there's grounds to terminate them for that because it is serious misconduct. Now, when you prepare the investigation report, you need to summarize the background. You can't just go into it and say, allegation 1 substantiated, allegation 2 substantiated. You should actually go through and say, well, this is when the investigation commenced. This is when we met with you. This is the complainant's version of events. This is your version of events. And then go allegation 1 substantiated or not substantiated, and then explain in detail why that's the case and provide the documents that you're relying on to support that finding. We want to avoid subjective opinions, of course. We don't want to say it is our view that you've done this. We want to say, based on the material provided to us and in line with company policy, you have breached or you have not breached. We don't want to use wording such as our view or it is our perspective or anything like that. We want to just be very clear on the facts and very clear on how we've arrived at our conclusion. And then including recommendations consistent with workplace policy. Now, that's more so when we're talking about internal investigations, not necessarily, or internal investigation reports that are provided to, say, HR or other members of management before we actually present the findings to the employee. So we're going through and we're saying, this is the background, this is the evidence, this is the facts, this is what we think the outcome should be for those allegations, and these are our recommendations. The recommendation should be tied back into workplace policy. So as a HR manager, if your senior comes to you and they say, there's been this, complaint, you need to investigate it, and you need to provide them with that report, make sure that you have a recommendation at the end that ties into workplace policy and say, I think we should do this. Again, you're not providing a recommendation to the employee in your outcome letter to them. It's just simply internally prior to that outcome letter being drafted. Now, when we're talking about determining the outcome, it's not always termination, of course. We've got further workplace health and safety or compliance training. Say you've got an instance where there's been alleged sexual harassment, but you couldn't actually determine that there had been that conduct that had occurred. It doesn't mean that we do nothing. It means that we do further training with those employees and we say, okay, well, let's actually get everybody up to speed on what is sexual harassment and what is required in the workplace. And you remind them of their obligations in their contract, what the company requires in terms of their policies, all that sort of stuff. Written warnings, again, if you've got an instance where you couldn't quite establish that it was serious misconduct and that they should be terminated on the spot, you can give a first and final, you can give a written warning, you can even give verbal warnings if it's not that severe. And then if we're talking about situations where it's a cultural issue, there's always the opportunity to redeploy the employee into a separate team, but we want to make sure that's in the same role, because if we alter their role to their prejudice, they have a general protections claim. Now, moving forward, if we look at the checklist really to sort of summarize what we've spoken about, we want clear and written procedures, trained and impartial investigators, documentation of all steps, transparent communication, and legal oversight when required. I think just to add on that, legal oversight as soon as you can. You don't want a situation where you've already conducted the investigation and you're at the stage where you're giving an outcome letter, and then you get legal advice and you say, okay, well, what should we do? Because what happens then is the documents that were all, prepared beforehand, likely there could be an argument made that they should be privileged. Because you engage in that process by yourself, it's likely that they'd be admissible in the commission or in court should it move forward. Now, we want to obviously create a culture of fairness. We want to have our employees know that we're doing the right thing and that we care about them and that we're taking their complaint seriously and that they'll be dealt with efficiently and with fairness, right? Because where we don't have that culture, we have employees who either leave or they make claims because they feel as though they're working in an unfair or unreasonable workplace, and it just becomes a spiral. And again, employees talk, they have those discussions amongst themselves, and then we have situations where you get bogged down with claim after claim after claim. So making sure that we have that culture. Now, reiterating, just to safeguard your organization, make sure you've got your policies. I'd say it's one of the biggest ones. Make sure your policies are actually in place, because you can follow a very good investigation process, but if you don't have a grievance policy or you don't have a code of conduct or anything like that, you don't really have anything to refer to when you're substantiating the allegations. It's quite hard to say you've engaged in serious misconduct, I must fire you, if you don't have a policy that says what's right and what's wrong. I mean, obviously, if it's objectively, blatant sexual harassment, you could just say, well, the conduct is against workplace law. But if you have the policies in place, you can say, well, you were aware that you shouldn't have done that. And because you've signed it and we've gone through that process with you and you've still gone against it. So making sure you have your policies in place. Training all your managers and your HR staff regularly. Obviously, there's lots of changes that come in. There's lots of updates. Specifically in Queensland, there's now the Sexual Harassment Prevention Plan, which requires all businesses to have a plan in place from the 1st of March. And if you're seen to not have a plan to eliminate sexual harassment in the workplace, there could be penalties issued against you. So if you don't already have that in place, I'd highly, highly recommend you have a chat to us. We can definitely get that sorted for you, and we can assist you with getting through making you compliant and making sure you have that documentation so you can say, no, I do have this plan. Keeping records at every step, of course. Allegations, evidence, meetings, and outcomes, everything's recorded. Appoint impartial investigators or external professionals where needed. Communicate outcomes transparently based on the facts. Common theme, always on the facts, not on opinion. Now, how we can help. So, we at NB, we do independent workplace investigations. We do HR and management training. We write policies and we do procedural audits to make sure that you are compliant. We provide advice on disciplinary action and termination, but we also are able to represent you in the commission in circumstances where you might engage us a little bit too late and the investigation has already sort of fallen over. We can represent you in the commission and go through some of those key points around, well, the conduct was so serious that it warranted immediate dismissal, and while the investigation might not have been conducted as good as it should have, we still had a reason to dismiss, and we can sort of run those arguments there as well. So lots of things we can help with. We're more than happy to help. And tying into that, because this is such a big issue that's happening currently and there's such a huge surge, we're actually having a limited time offer at NB where our workplace sexual harassment plan, again, that all businesses in Queensland specifically need to have, a full suite of employment contracts, so full-time, part-time, casual, and all our policies and procedures are half price, essentially. Those policies and procedures cover absolutely everything. It's pretty much a one-stop shop. We have a company manual that goes through everything, from the code of conduct to, a social media policy or even dress standards. Everything you can possibly think of is included in that policy. And if you need any tailoring, we can do that as well. But this is sort of your package to make sure that you are compliant. And if you need that training, we can get that in there as well. And we can have that chat to you and we can talk to you about how we can assist and how we can get you guys up to speed and fully compliant. So that is the end of today's session. We'll talk about those investigations. We'll open up the floor now to some questions from anybody. If you have any, feel free to put them in the chat, or if you want to turn on your mic and have a chat as well, you can definitely do that. But open to take questions for the remainder of the session for the next 7 minutes or so. So fire away. Okay, if we don't have any questions, I guess that's a good sign. Oh, here we go. So Helen says, do you support standing the alleged person down while investigating? Absolutely. So when we're doing an investigation, we need to make sure that, especially in serious circumstances, that the person is removed from the workplace. This also allows them sufficient time to provide a response, because we're saying we're actually removing you from the workplace. You can have that time to provide your response and you can go through all that material effectively. Standing down, we have to stand them down with pay is the unfortunate thing in a lot of circumstances, because if we don't stand them down with pay, you could have an underpayment claim. They can say they were entitled to compensation. They would have been working if the investigation hadn't been conducted, and they'd have a pretty strong argument to bring that underpayment claim. So yes, definitely stand, whoever you're investigating, definitely stand them down and remove them from the workplace. Because the other thing is, if you don't stand them down and it's a serious allegation, they might go and try and find that employee, and then you've got issues on site. So I hope that answers your question. Okay. If confidentiality is breached, this is Anne Herbert. If confidentiality is breached when you've warned an employee to not breach, is the employer liable? So it depends on the circumstance. If you haven't, well, if you have warned them and you've told them don't breach it, we've reminded you of your obligations and they do breach it, that's cause for dismissal, right? Because again, you've issued them a lawful and reasonable direction. They've breached that, and you can say, well, I've specifically told you not to release this information or have those discussions, and you've done that anyway. And our policies, if you have them in place, say that this information has to remain strictly confidential. If you don't have those policies in place and you don't have that discussion with them and they breach confidentiality, then it is likely that the employer would be liable, because the commission would look at it and say, well, was the employee aware of their obligations to keep things confidential? Were there any policies in place? What did you do as an employer to make sure that you did everything you could to make sure that the confidentiality wasn't breached at that time? So Those are pretty much the only circumstances, I'd say. If you've got everything airtight, you've got your policies, you keep reminding them, and they do it anyway, you obviously have to take action against them. And we'd recommend, at that stage, if it's serious, terminating them or going through a separate process. But yeah, in most cases, the employer is not liable unless you don't have your policies and you haven't had those discussions beforehand. What if they want an extension? So this is BJ Morse. What if they want an extension of time? Do they get one and fully paid? There are circumstances where an extension of time is granted. Tricky situations include where employees have got some of that sweet banked personal leave, and they decide, oh, well, I've been handed an allegations letter. I probably want a little bit more time, or I'm a bit stressed. They go to the GP and they say, oh, I want a week off. We don't want to terminate them, obviously, in that circumstance. We don't want to say, no, you don't get an extension of time because they've put a medical certificate in. So we allow that. But that extension of time in those specific circumstances, it comes out of their personal leave. In circumstances where they haven't taken sick leave and they want an extension of time, it depends on what's reasonable. So if you've got, as I said, that rule of thumb, 1 allegation, 1 day, that's just the rule of thumb that I follow. That's not law. Don't quote me on that. But, say you've given them a 3-page allegations letter and you've given them 4 days and they say, can I have an extension for a week? You can go to them and say, well, what's the need for the extension? And if they say, I just don't think I'll be able to respond in that time, then it's probably reasonable to say, well, no, you can respond in that time. We've actually stood you down so you have the time to do it. If they're saying they're traveling or something like that, there could be an argument that if that was annual leave that was approved prior, that you're operating against their entitlement to take that annual leave, and therefore they're in a situation where they're going, oh, well, they're taking adverse action against me. Ordinarily, in most circumstances, provide an extension of time. It's not going to hurt you too much. It's probably usually only a couple of days. If they want a ridiculous extension of time, you can go back and say, we'll provide an extension, but rather than 2 weeks like you've requested, we'll give you 3 days. The risk you run is if you don't provide an extension of time and they've got a valid reason as to why they need it, the commission can look at that and say that you're unreasonable. And then just to answer that second part of your question, yes, they're fully paid because they're on paid stand down. Darren Sherry says, are you seeing a rise in claims of psych injury by respondents caused by being investigated for the alleged conduct? Yes, we are. So specifically with work cover claims, I've seen a lot of psychological injury work cover claims prompted by investigations where you've got an employee who's definitely done the wrong thing. The investigation started and they've immediately put in a work cover claim and they've said, oh, well, this process has caused me such considerable amount of grief and I've got medical evidence. I need to be on work cover. And they get accepted in quite a lot of circumstances, and you've sort of got to argue against it and say, well, no, as an employer, we're allowed to investigate conduct that is inconsistent with our values and is against our company policy. But it's the way that you do it and the process that you follow. I mean, an employee you can't stop them from making a work cover claim. You can't contract out of it by law. But if work cover comes to you and says, we've had this claim put forward, provide your reasoning. The test there is reasonable management action taken in a reasonable way. And if you've done that, you can argue that the claim should not be one for acceptance. So Anne Herbert says, what do you do if a person raises a concern that relates to sexual harassment or bullying, but you don't think it's warranted? How do you handle that? Well, when you say you don't think it's warranted, do you mean you personally? Because in those circumstances, I would engage an external investigator and I'd seek legal advice from a solicitor on those specific circumstances. And I'd go, look, we just have this question. Is this valid? Are these real concerns? Because the thing is, if the employee is saying that they feel as though they've been sexually harassed and they go to a doctor and the doctor then goes, this has had a real effect on them, and they issue their medical certificate and say, they're injured, then even if you don't think that it's warranted, the doctors then back them up and said, oh, well, they've suffered an injury now because things haven't been investigated appropriately. So I guess to answer your question, I'd engage an external investigator or seek legal advice. Warren, are you able to advise on the suggested approach to deal with abandonment of employment issues, i.e. if an employee hasn't attended work for a few months and continually making up excuses? So abandonment of employment is on medical grounds. You've got 3 months. If an employee is not returning to work for a period of 3 months, you can go to a stage where you can say, well, look, you're not attending attending the workplace, you're not performing in your role. We might have to cut this off. Depends on the circumstance again, though. If they are consistently providing medical certificates and they're on work cover, or there's an issue there, you can't really do that. What you can do is you can go through a process where you go, okay, well, I need you to provide me with a document that tells me when you're going to be fit to return to the workplace. If they're just providing excuses, but they're not actually providing documentation, then you can push back and you can say, well, no, I need a document that says when you're going to return to the workplace or what reasonable adjustments you need, if any, so that we can get you back on track. They keep pushing and pushing and pushing and they're not coming back with anything reasonable, then you can just say, look, we're not confident that you are able to perform in your role and that you can perform the inherent requirements of your role. And you can go down a process where you show cause them. You can say, essentially show me reasons why you should remain employed if you aren't attending work and you're not providing any documentation that says you can't work. But when you go through that process, highly recommend engaging a lawyer, engaging us. We do that all the time. And if you do it incorrectly, you're opening yourself up to a work cover claim and also a discrimination claim or a general protections claim. So there's a lot of risk there. Definitely get advice. Do you have any legal recourse for contractors who are involved in a workplace investigation who might breach confidentiality? Because that's a bit of a tricky one. So that's a question from Melanie White. If you've got a contractor who's involved in a workplace investigation and they breach confidentiality, what you can say is because they're not an employee, they're not necessarily held to the exact same obligations as your other employees would be, but you can set the expectation with them and say, I'm engaging you to perform work and the work is being given to you by my business. This is meant to remain strictly confidential. And if you breach that confidentiality, we might have to terminate our engagement with you. Obviously, depending on the circumstances that are surrounding it, but you can reset those expectations to them. It's just a little bit harder, obviously, because they're not an employee. Susan Moore says, what are the employer obligations should the employee talk about concerns or behaviours of a colleague, although does not want to make this formal or in writing? Example could fall under racial concerns. Okay, if they don't want to make a written formal complaint, best course of action there would be to organise a sit down where you sit, the HR manager or the HR manager and the employee, they sit down privately and they have that discussion. And then the HR manager says, if you're okay, I'd like to write down and record what you're saying to me. But realistically, if the employee just wants to vent and they don't actually want to make a formal complaint or they don't want you to pursue anything, you then have to keep that in mind. And it might be because of their concerns in terms of they don't want to be victimized, they don't want to have anything held against them in the workplace. But if we're talking about very serious conduct, you have an obligation to make sure that you investigate it. So you'd have to reset that expectation with the employee. So in terms of racial concerns, though, that's definitely something. I'd have a sit down and a chat with that employee, and I'd say, if you want to make a formal complaint, we can investigate it. But if you just want to sit to me and have a talk, we can do that too. And then an avenue there would be making training happen for that organization and going, just so you guys are all aware, this is what discrimination is in our workplace, and this is what the workplace health and safety laws and the anti-discrimination laws require, and then training those employees and saying this is what is required of you. And if anything comes up further, you can say, well, you've had the training, we've had that discussion already, why are you engaging in this conduct? So Heather says, if an employee is on a medical certificate after a disciplinary process has started, are they required to obtain medical clearance to attend further disciplinary meetings? Or can they provide written confirmation agreeing to attend? What would be considered best practice in the situation? It's a very good question, actually, because you'll find on a lot of medical certificates, and this gets argued fairly extensively, it'll say, so-and-so employee is unfit for work for this period. Unfit for work doesn't mean unfit to participate in the investigation. It just means you're unfit for work. If they have a medical certificate that specifically says unfit to participate in the investigation or unfit to engage in the process, that's different. But we're not requiring them to work, we're requiring them to engage in the process. So if they're on a medical certificate and they're saying, I can't attend disciplinary meetings, then we can push back and we can say, well, your medical certificate doesn't say that. Your medical certificate says that you can't come to work. Doesn't mean that you can't participate in the process. We can't delay this investigation purely because you're saying you can't come to work. So it's got nothing to do with you performing at work in your role. This has got something to do entirely with these allegations that have been put to you. And you can push back on that. Again, I get legal advice depending on the circumstances. Like if we're talking about an employee who has a psychological injury and engaging in the investigation process is causing them significant mental strain, you'd want to approach it a bit more delicately. You'd want to offer EAP. You'd want to say, look, we're here to support you. We understand this is a very stressful process, but we do need to move forward. There's different approaches for each circumstance. Fantastic. Well, thank you so much, guys. Just to tie it up, we've got some upcoming webinars. So we've got our migration team. We've got 3 wings: migration, commercial, and employment team. The migration team is doing a ask anything, any visa questions you could possibly have. They're willing to go through that webinar and talk to you about those requirements and how we can help you with maybe getting some employees over or engaging some contractors and things of that nature. The next webinar on the 21st is property valuations and AI, what you need to know before you purchase a property. And then on the 29th, Business 101, how employer-sponsored visas could be your workforce solution. So fantastic, guys. There's a QR code link here where it takes us to, or takes you to our website and shows you what we offer and how we can assist you guys. And again, if you have any questions or any concerns, or you just want to have a chat, or you need anything looked at, or you want those policies updated, or you want to engage in that compliance month, which I'd highly recommend, feel free to give us a call, have a chat to us. We'll help you moving forward, and we'll help you stay compliant. So thank you so much, guys. Great questions. It was good to chat to you all, and I'll see you all at the next webinar, which I think for employment might be next month around this time. But yeah, take care, guys. Thank you. Bye-bye.